So there's quite a lot of important information and knowledge here that we've got to digest this and use logic to work out where we are now with the right to petition. So I found quite a few more information sources of standing orders and things like that. Funnily enough, these ones don't have the Tumultuous Petitioning Act referred to in them. I don't know how this information just seems to be appearing. It's almost like someone's just drip feeding me it when I didn't find it before. I've got this distinct notion that, why didn't I find it before when I was looking for it? I always kind of, I don't think I wasn't typing the right things in. And I was searching before. People do know these things, but I don't think that they've put them all together and kind of focused and channeled it to hold the government to account on the current process and where we stand with it now in relation to all these legal cases and actions. I think that it's just kind of in the knowledge of students, historians, researchers, people in history, and it's kind of like known, but known in sort of a kind of diffused and separated manner. Some people in Parliament might know, but they're not really helping us. So that's one thing for sure. So my last video, really this video should have been with the last one I made, but I'll upload it after it, so it should be right next to it. And there was only a little bit to add to this now. So following on from the last video that I made last night, there's only one thing to add to this data and information concerning this 1669 resolution. And in the last video, I pretty much outlined why I believe the resolution was required and what it's very likely it was needed for. And that is absolutely and completely logical. Now, the last part of this, at the very bottom of here, there is a sentence what says how far they are fit and unfit to be received. Well, the word of interest is far. How far they are fit and unfit to be received. Well, what I said is that the current people who have knowledge of this source of writing, this source of information currently in Parliament, if they do, I think they've superficially and quite shallowly read and interpreted that without really thinking about it and without fully applying what is known and understood about the Tumultuous Petitioning Act and those procedures to it in a logical, intellectual manner. Now, so therefore, well, they interpret it and look at it very superficially as if, if petitions are fit to be received, standards, or unfit to be received, and even if they should receive them, basically, they're reading it and they're actually interpreting it or wanting to interpret it as if they somehow might not wish to receive them or might wish to reject them, or if they're not even fit. But I can assure you that this sentence contained here is saying how far they are fit and unfit to be received in relation to them being referred through the legal process that was in place in the 1661 Act, and the justices, London magistrates, or larger part of a grand jury that were checking these large petitions that were from large numbers of people. And that is, like I said before, where there was a lot of people. If it was over 20 people, it could have been 50 or 100, and they might have all wanted to write something down or, have a separate statement or petition on the same matter, and they might have been trying to say that only one of them could do it on behalf of the others, and that each person didn't have a right to all that. So I'm quite certain that that's what it's about, because if it's under 20 people, it could go straight to Parliament, and it's a resolution over a dispute. I think that there was some argument over referring them and sending them to Parliament, whether they should or not, after they've been logged, filed and checked by these other judicial bodies. And I think that's why, if they are fit and unfit to be received or not, a Parliament should decide that, not the other jurisdiction or the other bodies that are looking through them. They was made there to basically file and record them and so forth. I guess it would be, how I can give an example of that is, like if you get, I don't really want to use the appeal process, because, when you're petitioning, you're starting out fresh, from new. But so if you appeal from a magistrate's court to a Crown Court, you're meant to submit one of the forms to the magistrate's court and one to the Crown Court. You do submit it to the Crown Court, but let's say the magistrate's court were forwarding it to the Crown Court and they didn't think it was fit to forward it, although you're appealing to the Crown Court. I think that this, how far they are fit and unfit to be received, I think that would, a good example would be to say, it would be for the Crown Court to decide that, not the Magistrates' Court. Although you've got to, submit one to the Magistrates' Court, a copy, but you also, it's kind of that kind of situation. I think there was some dispute with the other bodies and authorities. It's not about how the Petitions Committee are kind of choosing to use it now. And then my final bit of this discussion, which is kind of the only part that I really wanted to make this video for, add on to the other one, because I'm kind of like going back a bit on what I said in the last video, referring to those matters again. So this is 1669. We're getting closer to 1688 from 1661, closer to 1688. And this is a resolution. 1669 is a resolution because they got issues with what was 1661 Tumultuous Petitioning Act procedures, right? Let's get that clear. It's a resolution. And it's definitely to do with, I think it's to do with large numbers of people and arguments and disputes in submitting their petitions, and who's got the right to submit on the same matter, whether it's on behalf of everyone or everyone sort of separately can submit on the same matter, which is what we've got, amalgamation. Probably over, a lot of people didn't know how to read and write back then, and they got other people to write them for them, like a lawyer or a priest, or someone who could read and write. And also they sometimes got people to just put their mark on them. If they couldn't write themselves, they just put like a mark on it or something like that. It likely is things in and around that, not actually, if you're competent to read, to write or not. I think we're talking about, the actual ability to read and write, literacy completely, not on actual great scrutiny of the content or eligibility or anything like that they're currently doing now with their ridiculous excuses. In fact, it's the Petitions Committee who don't bother reading and looking at the law and don't understand it a lot of times. But what this last sentence here, what revelations I've got from looking at it now, and I think these are very, very, very important, strong revelations, and that is that after 1669, after this resolution, when we get to 1688 and we actually get officially, this is when, the most notorious and famous out of all this And really the only main law that people know about, because all this other stuff is like, I've had to learn about it and it's more lesser known, is the 1688 Bill of Rights, obviously in the claim of right, 1689, the Scottish one that can't be imprisoned. It says that it is our right of the subjects to petition the king, and all commitments and prosecutions for doing so are illegal. So I would say that this resolution was attempting to clear up some issues and problems that were happening from the 1661, particularly through these other bodies that were involved in the process. I suggest that, and therefore they needed this resolution. After this resolution, and obviously we've got, conflicts with kings coming in and out and Glorious Revolution and all that as well going on at the same time. But this is like, this is synonymous with starting it's almost kind of like nearly as important, the Bill of Rights, really, as the American Constitution. But I think that they're I think in the 1688 Bill of Rights, they're making a catch-all resolution which really was supposed to, go further than this resolution and then completely and totally, hopefully, make a permanent resolution with great clarity, which is that, you can't be held to, we're not going to be held to any commitments, because here, it might have, I think the case was that from the 1661 procedures, there were clearly some issues of petitions, not getting through and so forth, and therefore the other bodies, therefore, were deemed not to be, the deciders, but Parliament instead. And people had a right for Parliament to be the deciders, not these other bodies that they put in place through the 1661 Act, and then who could and could not even submit to those bodies when there was in mass numbers, like everyone as an individual as well, or just one person acting on behalf of them all. And then I would say that, so I strongly believe now that it's clear that when they say, no commitments, that would be to any form of rejection at all or dispute. Because I think that it was the other bodies that were involved, which are named and outlined in the 1661 Act, Tumultuous Act. I think there was some disputes there, and that, Parliament would decide, not them. And then I think finally, they just got rid of all disputes and uncertainties by just saying, look, we can't be held to any commitments at all, and I think that would be a final resolution, or supposed to be a final resolution, and also also for the prosecutions as well and imprisonments, because the reason is that that 1997 Justice of the Peace Act, the annulments is that when you're pursuing to get legislation changed or overridden, or an order from a local authority or an order from a court, the previous order is annulled. We know that when you appeal from a magistrate to a Crown Court, it gets, you're having it heard again, and unless you're in prison, you can apply for bail. But what I'm saying is that usually, in particular, like you can get your driving license back and things like that, or you don't have to pay your fines or carry out your sentence until once the appeal's been received by the Crown Court, it's meant to be. You're not, you're not subjected or liable to, the magistrate's court order. It's, I don't want to use the word suspended or annulled or whatever, but it's set aside. All those are terms which, have their own meaning, but, obviously say that nothing happens until, the Crown Court, and if you pursue it, unless you withdraw it, and then obviously the, magistrate's court order is put back in place, and I think that's how it works. I think that, so therefore, you see, you are supposed to be able to appeal decisions made by local councils, and therefore, if it's a planning decision, then obviously it's annulled and pursuant of a resolution of Parliament. But that would mean that you can. I mean, look at John Pym and John Bastwick and Henry Burton, getting criminal charges petitioned about to get released, you know, it's annulled. So I think that what's happening with the immunity and illegal prosecutions and so forth in the 1688 Bill of Rights and the claim of right is that effectively pursuant of a resolution in Parliament, if there were any criminal offences or charges in connection with, you know, your bringing the case activities, then they're kind of like almost like permanently suspended or annulled while you're pursuing it. The same as any other order, really. You know, whether it's really the order that you know, if it's a local authority matter that you want to take to Parliament for a resolution, then that is annulled or suspended pursuant of the matter, along with any, you know, these criminal charges and offences. You see, they weren't in the 1661 Act. They still had a special process for offences and prosecutions in connection with the petitioning. But so the 1661 Act, it's the right of the subjects to petition the king, and all prosecutions and equipments for doing so are illegal. Well, I think that was the final resolution. That was meant to be the final resolution, really, to all of it, pursuant of a resolution. Well, that's what it is. You see, it's the ultimate resolution in pursuance of a resolution. You could say that it's the resolution of resolutions because you're in pursuance of a resolution. So all matters are pending resolution of the resolution. So, you know, and then my final part to say on this part here is how far they are fit and unfit to be received. Well, the word far, how far? Well, the thing is, when you're petitioning Parliament, you have these committees, but then you also have the chamber and debates. But ultimately, on the basis that if you're wanting to get the law changed or a law made, which are the main things that you're petitioning about, or even, I mean, Richard Tice said that you can get convictions overturned, and the process kind of is almost like putting a bill through or whatever, or an instrument through to get it done. So that's kind of like going through Parliament. So it goes from one house to the other house, and, you know, it gets signed off by the king. So ultimately, I think what this means here, therefore, and this is my final answer on this bit, is that so ultimately it's going to get, you know, signed off by the king. In theory, that process is bound for, you know, passing by the House of Lords, whether or not it's legislation made, changed, or even, you know, to get these criminal matters dealt with. It's bound for the House of Lords to be put through after the Commons. And I think that is playing on the word how far they are to be received. Well, it's going to be all the way, you know. Or it's intended, it's pursuant of getting it all the way. So, and I think that, therefore, when this resolution is made before the 1688 Bill of Rights, this 1669 one, I think the word how far is like from those other bodies that were officially declared as part of the prescribed process in the tumultuous act. Because, you know, how far are they to go past there to get to Parliament, you see? There clearly was some issues why they need this resolution. So Parliament has got a right and a privilege to receive them. And then, you know, in 1689, you know, it is the right of the subjects to petition the king. Obviously, without any question or doubt in between, or any rebutting or anything like that, you see. So really this how far, I think that's why they say, right, well, we know how far it's going to be if you're in pursuit of it. You know, you're you know, And I think that is why that they made that 1689 clause. And I don't really think it's anything to do with the petitions committee in Parliament doing this stupid rejection business, or saying, don't know what you're asking, or whatever, because, there are processes where they call people in for clarification. And I've actually been reading a lot more about the process of the petitions committee and people giving evidence and so forth. Apparently it's a lot more engaging. I don't know who these people who have been engaged in that process and who have been calling in, because at the current moment they're doing it on numbers of signatures. They're doing it on, you get a response after 10,000 online, and you have to get 100,000 signatures. Like Tess Lowry was a person privileged to be invited in, and then there were various committees that invite people in to give evidence, like that Merlin Sheldrake guy was in the other day, but I don't think that was to do with a petition. It was just the Technology and Innovation Department wanted him in to give evidence. But I've actually read an older document from Parliament, well, not that old, and in the last 10 or 20 years, and it's given like a lot of, these are people like, Laura Corrigan with the tampon tax laws, people welcomed in. Oh, Theresa May, welcome, Laura. Come in. Let's ask you some questions. Delighted to see you. You mean Paula Sheriff, tampon tax. Unfortunately, most people who are petitioning Parliament aren't so, on the side of the political parties. They're usually opposing against them, and, on the verge of grievance. They don't really want to talk to them other than, complain. And they're the last people that they want invited in to give evidence and, engage further than that. But they're clearly, it outlines, there are people out there walking around this country who have, engaged quite deeply in an actual process, which is similar to, any civil or other police investigation, but obviously in Parliament. So I think that we are being, and I don't. It can't only be people from Oxford University, on the politics course, or Merlin Sheldrake, or whoever. There's a lot of people in Extinction Rebellion in Oxford University who pop up in videos who sound very eloquent and educated, but they don't seem to be giving us accounts of nice tea parties in Parliament, in committee meetings and interviews, officially giving evidence and investigating. They seem to be on the side of Extinction Rebellion, complaining that where they've tried everything and nothing works. So it does leave you scratching your head, really, to who these privileged people are. And by the time, they're finished with brickwalling everyone, and by the time, they've illegally prosecuted people through the courts, and everyone's kind of like a ragdoll being dragged through a bush, no one really wants, wants to engage with them, other than, scream and shout at them across, Parliament Square, shouting free Assange, and then the police, don't even let you anywhere near the building. So, they're not helping themselves out, really. You see, that Tumultuous Act really did make it an official process and control the numbers of people who were officially doing it and registered, so there was no doubt and question about it. So you didn't have all these, random protesters and demonstrators who, are they not? But then again, according to this, when it was large numbers, then there's actually nothing that prevented people from making separate representations on the same matter. It was their right, and that was what one of this resolution was for, actually.